What do we got, 2296?
Mr. Chair, members, House Bill 2296 allows a person with a restriction on their driver license or permit to transport a dependent person between their residence and the dependent person's employment, school, or medical appointment, and drive between their residence and a court-ordered screening, education, or treatment for scheduled appointments. Additionally, the bill states that a person whose driving privilege is revoked for a violation of reckless driving and who is sentenced is eligible for a special ignition interlock restricted driver license after completing at least 45 consecutive days of the revocation period required. House Bill 2296 states that a person is guilty of aggravated driving or actual physical control while under the influence of intoxicating liquor or drugs if the person is driving under the influence and the wrong way on a controlled access highway or state highway. Finally, the bill requires a law enforcement officer to forward the certified report to ADOT within 30 days after the arrest and prohibits the report to be used against the person and the person's driving privilege to drive is not subject to any penalties. And with that, I'm available for questions.
Members, any questions for staff? Seeing none? I guess I'm the bill sponsor, aren't I? Aaron did a fine job. We also have one of the guys that's kind of responsible for most of this language. And we are, yeah, so Mr. Steve, come on up. Talk to this bill.
Mr. Chairman, members, thank you. My name is Stephen Scharboneau. I worked on this bill with the chairman last year. We worked with several stakeholders, including law enforcement representatives, and we started with this bill. The idea of the bill was to clean up some problems that we saw in the legal arena with the way that some of these things work, like restricted driver's license, wrong-way driving, and driver's license at the suspensions and revocations at the Arizona Department of Transportation. The provisions of this bill are aimed to fix that. We've called it a cleanup bill. I know when we started with the language, there was a lot more involved, and there were some issues that it was not a cleanup bill. And we heavily cut down on the provisions that were in the bill to ensure that it was an actual cleanup bill. There's a lot going on in the bill, so if anyone has any questions, I'd be happy to answer those questions.
Mr. Chair, I have a question.
All right, well, first of all, Mr. Kavanaugh.
Okay, thank you, Mr. Chair. I'm sorry, what group do you represent?
I'm here representing myself.
Okay. I'm just curious, because I thought some of this was already in law, like being able to drive your kids to school. So is that not in law now, or is it not in law up to a certain class of people?
Mr. Chairman, Representative Kavanaugh, it is law to drive your kids to school. The restricted driver's license under 28-144 has dependents that are living with you. What this would do is allow you to drive your dependents that are not living with you as well.
Okay. And, Mr. Chair, also, it's my understanding that if you have a restricted driver, that once you're like arrested for whatever the charge is, that you are allowed to drive without an interlock for a certain period of time while you get your affairs together. So this mentions that a person can only get a restricted license 45 days of revocation. So are you now taking away somebody's ability to drive and get their affairs in order before they have restrictions on them, or?
Mr. Chair, Representative Kavanaugh, thank you for the question. So what that portion of the law deals with is it deals with three major motor violations, okay? It deals with reckless driving, aggressive driving, and drag racing, I believe, off the top of my head.
Yes.
And those are the three major motors that it deals with. The problem that this part of the bill was trying to address was that if a person was convicted of, let's say, 2 DUIs within a 24-month period, that person, on the second conviction of the DUI, would be eligible for a restricted driver's license upon conviction through this CERTL driver's license.
Right.
However, if a person was convicted of, let's say, a DUI and then a reckless driving, they would not be eligible for the restricted driver's license. They would have the hard revocation.
Right. So I'm looking at the summary, and it says states a person whose driving privileges are revoked for a violation of reckless driving and who is sentenced is eligible for a special ignition interlock restricted driver's license, the CERTL, right?
Yes.
After completing at least 45 days of revocation. So does that mean that, so I thought now they can drive right after they're convicted, and now you're saying, no, they have to wait 45 days? Or is this not properly summarizing the bill?
Mr. Chairman, Representative Kavanaugh, there is a 45-day revocation. Remember that we're talking about after a conviction, not pre-conviction. So upon arrest, as you mentioned before, for a DUI, if a person's arrested, their license is taken from law enforcement officers, and they are given a paper where they're allowed to drive for a certain amount of time until they go and have a hearing with ADOT. And that is completely distinct and different from this part of the bill. This part of the bill is after the conviction.
Okay, okay. I'm done.
Good explanation.
Thank you, Chairman.
Any other members?
Mr. Chairman, just one
I'm
follow-up to
sorry. Thank you.
Mr. Kavanaugh.
Thank you.
Thank you. Mr. Kavanaugh asked most of what I was going to ask, but also, Stephen, so this requires an interlock device to be placed in the vehicle, is that correct?
Go ahead, Steve.
Mr. Chairman, yes, it would require an interlock. It references the statute. I apologize. My printer went down, so I don't have the bill in front of me. But there's a statute that governs all the requirements for a CERTL, restricted driver's license, and you would have to abide by those provisions. I'd also like to point out that although there is, a lot that goes with that, it would be better than what is happening now, which is a 12-month, I believe it's a hard revocation.
Thank you. And Mr. Chair, one follow-up.
Yes, please.
Thank you. Stephen, can you talk a little bit more about who the stakeholders were involved in the development of this bill?
Yes, Mr. Chairman, Representative, thank you for the question.
Please go ahead.
So last year, we had multiple stakeholders, which involved defense attorneys from Arizona Attorneys for Criminal Justice. We had law enforcement agencies, including the Fraternal Order of Police, and I believe the Arizona Police Association.
That's correct. They were both there.
Yeah, so I think there were others involved. I just don't want to misspeak and say that someone was there when they weren't. But
Some people from the courts as well.
The courts, that's right. Thank you, Chairman. There were quite a few individuals from diverse sides to come up with the language of this bill.
Thank you so much.
Just,
Mr. Kavanaugh.
thank you, Mr. Chair. Just one quick one. So I'm looking at the summary too, and it mentions that a person whose driving privilege is revoked for reckless driving and is eligible for an interlock. So that means that the person not only committed reckless driving, but was a DUI?
Mr. Chairman, Representative Kavanaugh, yes.
Okay, so you're not requiring an interlock on somebody who just did reckless driving without being intoxicated?
Mr. Chairman, Representative Kavanaugh, that's correct. So this has to do with two convictions, not one. This would be with two. And we're just trying to bring a little bit of parity to, we're looking at this, and I mean, I guess this only makes sense if you're under the assumption that a reckless driving is a lesser crime than a DUI. And that's the assumption that we're operating on. And if everybody agrees with that, then what we're saying is, let's allow those people who have committed the lesser crime the same eligibility as those who are eligible for the greater crime, if that makes sense.
All right, just, Mr. Chair, just to be sure. So under this bill, a person convicted of reckless driving who was not drunk does not have to get an interlock?
Chairman and Representative Kavanaugh, I believe there is a way that could happen. If an individual was, I believe under the language, I'd have to look at it again, I really wish I had it in front of me. Under this language, I believe if a person was convicted of a DUI or extreme DUI, and within 24 months, that person was also convicted of reckless driving, let's say, at that point, they would be eligible for the CERTL, the ignition interlock.
Mr. Chair, based on their conviction for DUI, or because they now committed an offense that had nothing to do with alcohol, but they previously had to have an interlock? So are you bringing back an interlock to somebody who already had it and finished it because afterwards they committed reckless driving that might have nothing to do with alcohol?
Mr. Chairman, Representative Kavanaugh, I'd have to look at the language in the actual CERTA requirement. I believe off the top of my head that there is language in the CERTA requirement that alcohol was involved for them to have the interlock device. For instance, I believe if there was an A3 charge, let's say a 28-1381 A3 charge that has to do with drugs, not alcohol, in those circumstances, they would not have to have the CERTA on.
We're talking about the second arrest, not the original one way back, 24 months.
If I may, Mr. Chair, Mr. Kavanaugh, to be clear, I believe, and I'd be happy to chat more with you about this, Representative Kavanaugh, if you'd like to have a meeting and go through the.
Yeah, Mr. Chair, maybe in the interest of time, maybe staff could get together and maybe have, was it Mr. Premack, I assume, did this bill? Just to allay my concerns that we may be requiring an interlock for somebody who previously had one, ended the interlock term, but now is doing an unrelated bill to alcohol, and we're suddenly saying you have to get the interlock again. I just want to make sure that we're not doing that. It doesn't sound like that's your intent, but let's just make sure that that is that way.
I believe the actual intent, Mr. Kavanaugh, was to, when they get that second offense, not the interlock, but their driving privileges get suspended, and with 2 DUIs, they don't. They end up with an interlock, but they can still go back and forth to and from. But with the reckless driving or speeding, they actually lose that driving privilege for a certain amount of time. I don't recall how long that was. Is that correct, Steve? Am I summarizing it?
Mr. Chairman, thank you. Yes, I believe that is correct, and I see where Representative Kavanaugh's concerns are coming from. That was not the intent, as you had stated. However, I think that we are covered. I'll go back and look at it to make, double sure and get back to people. But I think that we're covered by the actual language in the interlock statutes. I think there is some requirement there that there has to be alcohol involved to have the interlock.
Yeah, I mean, Mr. Chairman,
Yes, Mr. Chairman.
we could check with Mr. Premack, but I think if we specifically state in this case they do get an interlock even though there's no alcohol, this being a more specific section of a law would override the more general restriction. So let's just make sure that what you don't want to do is not actually happening. So.
Thank you.
Any other members? Hearing none. Thank you, Steve. Great
Thank
job.
you, Chairman.
Mr. Vice Chair, do we have anybody signing?
Signed up. We don't have anyone else signed up.
No? All righty.
Can you move?
Members, any final discussion? Hearing none. Secretary, please move the bill.
Mr. Chair, I move that HB 2296 be returned with a due pass recommendation.
Thank you. The question before you is that HB 2296 be returned with the due pass recommendation. Secretary, please call the roll.
Representative Andrade,
Aye.
Representative Blackman,
Aye.
Representative Burgess,
Toe up.
Thumb up.
Yeah, she said yes.
She said yes?
Well, she signaled.
She put her foot back up?
Yeah.
All right.
It's her thumb, it's not her foot.
Representative Fillmore,
Aye.
Representative Fincham,
Aye.
Representative D. Hernandez,
I don't see him. I don't hear him.
He's muted.
He is muted. There he is.
Sorry, aye.
Representative M. Hernandez, Representative Germain,
Aye.
Representative Kavanaugh,
Aye.
Representative Longden, Representative Roberts,
Aye.
Representative Sosi,
Aye.
Vice Chairman Nguyen,
Aye.
Chairman Payne,
Aye. Wow, kumbaya land.
Yeah, don't get too carried away.
Thank you. By your vote of 14 ayes, 0 nays, 0 present, 0 absent, you have given HB 2296 a due pass recommendation. And thank you, members. Good job, Steve. Where'd he go? Oh, there he goes.